Thanks very much, Marshall, and it was good to have all those fabulous memories of Brendan Nelson flooding back for us. Our next speaker is Nicholas Cowdery. Nicholas was the Director of Public Prosecutions in New South Wales from 1994 to 2011. He'd been a barrister for about 40 years, Queen's Counsel for 24 years, and an occasional acting judge of the District Court. He's been President of the International Association of Prosecutors for 6 years and inaugural co-chair of the International Bar Association's Human Rights Institute. He'd authored a terrific book called Getting Justice Wrong, Myths, Media and Crime, and he's been a member of the New South Wales Sentencing Council and numerous other organisations. He's now a visiting professor at several universities and was recently awarded an honorary doctorate of laws by the University of Wollongong. And he undertakes consulting work for prosecution agencies in developing countries. And he's going to speak to us now about the legal aspects of legislative reform. Nicholas Cowdery.
Thank you, Richard, and good afternoon, ladies and gentlemen, and thank you to the organisers for the invitation to come and speak to you this afternoon, I think. I've been asked to speak about some of the legal aspects that touch on the discussion that we're having this afternoon. I suppose that's natural enough, but I'm going to try to avoid politics, having had a nodding acquaintance with some aspects of it over the last 16 and a half years. I'm conscious of the fact that we meet in the basement of a building that is known for other sorts of activities. Sorry, Kate. We have laws to regulate our conduct. And of course, we need to have those rules to allow us to continue to live in harmony and to settle disputes that will inevitably arise about matters in life. And we have criminal laws to criminalise, to enable penalties to be levied on conduct that is detrimental to the rights of others and to the integrity of society. And I'm not for one moment arguing that we should not have such laws. But there are areas of life, I think, in which the criminal law has either no place or a very limited place. And that really is the thrust of what I have to say this afternoon. I've mentioned rights, and I think it's salutary to go back to the International Covenant on Civil and Political Rights, which is the international instrument which sets the standard for rights and, yes, responsibilities that attach to the conduct of all of us in civilised societies. And in Article 6.1 of the ICCPR, it is said this: every human being has the inherent right to life. This right shall be protected by law. No one shall be arbitrarily deprived of his life. 3 short statements in that one sub-article. Now, they seem clear enough, I think, and it's clear also, to me at least, that the right to life is the starting point for a civilised society, for civilised living amongst our groups, our communities. But being a lawyer, I really can't resist identifying some difficulties that lawyers argue about just in those 3 short, simple statements to show you just something of how difficult it is for these sorts of issues to be carried forward in political circles and in both domestic and international fora. The first statement: every human being has the inherent right to life. Well, does that mean that the state cannot legislate even to allow somebody to forfeit that right. And there are arguments about that. The second statement, this right shall be protected by law. Does that mean that law that infringes that right or impinges upon it is not valid? And no one shall be arbitrarily deprived of his life. Does a law that allows somebody to surrender his or her right to life and allows somebody else to assist in that process amount to arbitrarily depriving somebody of the right to life? We might all have pretty straightforward answers to those propositions, but let me tell you that there is a huge volume of legal discourse that has risen up around those propositions since the ICCPR came into force in 1976. A lot of lawyers writing a lot of words. While I'm on the subject of words, we talk about euthanasia, medically assisted death, we use other expressions. I prefer the description, which others use too, of voluntary assisted suicide. Because I think that those three words capture the three elements that we should be addressing, at least at the first stage of the development of legislation of this kind. This may well be a progressive process. It may well be a process that begins with one set of circumstances and then perhaps after a time and after discussion and debate and the consent of the community extends to another set of circumstances. But let's come right back to the beginning, because in New South Wales we really are starting at the beginning. Voluntary assisted suicide. Voluntary because it is the product of informed consent. Free and voluntary agreement to the action that will end life. So implicit in that is the ability of the owner of the right, the holder of the right, to understand and to consent. Informed consent to the action that will be taken. Assisted suicide, involving the activities of other people to bring it about, to enable it to occur. And therefore, there need to be provisions that will protect people who may be involved in that process, be they doctors, nurses, family members, whoever it might be, who has some input into the decision-making and into the action that is taken. And suicide, the ending of one's own life. Even if another party is involved, even if another party assists. Essentially, what we are talking about is the ending of one's own life. Not the taking of somebody else's life, the ending of one's own life. So voluntary assisted suicide, I think, is a very neat way of describing what happens, but also of identifying the particular issues that need to be addressed. Now, in the present criminal law regime, we have a number of offences that apply, even when voluntary assisted suicide is what has happened. We have murder, we have manslaughter, we have aiding suicide, and we may have other offences as well, conspiracies, incitement, and other formulations to capture the conduct directed towards the taking of the life. Now, I'm not saying we don't need those laws. We do. We need them for other circumstances. Murder is the taking of a life with the intention to kill or the intention to cause grievous bodily harm, or recklessly as to whether or not death will occur. Manslaughter is all other unlawful homicide, very often in circumstances of extreme negligence towards the victim. And we have other offences of infanticide and suicide and so on. Actually, we don't have an offence of suicide anymore. When we first inherited our criminal law from England, we inherited the offence of suicide. It was a criminal offence to commit suicide. Not a lot of people were prosecuted for it. But there were two aspects that were inherent in that. One is that it came to us from the Christian religion, and that was reflected then in the secular laws. Those sorts of influences maybe are not quite so strong these days, although one hears argument to the contrary. The other aspect of having suicide as an offence meant that ancillary offences, aiding, abetting, assisting, counselling, inciting suicide or attempted suicide, could be made criminal. Now, over time, we've got rid of suicide as an offence. It's farcical. You don't prosecute dead people. But we still have, in the Crimes Act of New South Wales, the offence of aiding, abetting, inciting or counselling suicide or attempted suicide. And it's regarded as a very serious offence because the maximum penalty prescribed is 10 years imprisonment. And it's an offence that applies regardless of the circumstances, regardless of the nature of the person who dies, the physical or mental capacity, regardless of the circumstances. If you aid somebody to take their own life, you commit, in our criminal law, a very serious offence. And frankly, while there may arguably be some circumstances where that is appropriate, we don't want people to be going around encouraging other people to take their own lives as a general proposition, I think obviously enough there are circumstances in which that sort of conduct should not be dragged into the criminal law. The criminal law is not static. It evolves over time, and it evolves to meet changes in social circumstances, changes in the nature of society as it evolves itself. And we've seen a lot of evolutions in the criminal law. It's not so long ago that abortion in any circumstances was a criminal offence. That has changed. We haven't seen that law being abused. It's not so long ago that homosexual intercourse between consenting adults in private was a criminal offence. That has changed. That is no longer a criminal offence. And society doesn't seem to have collapsed as a consequence, although there may well be some who would argue to the contrary. But things do change, and we have improving standards of education in the community, which means that people generally are able to access more information and to make reasoned choices about their conduct that are based on that information. We've seen an increased ageing of the population, which brings with it the diseases and ailments of ageing that previous generations have not generally encountered, and the problems that that gives rise to, many of which we're talking about this afternoon. We've seen advances in medical science, both in prolonging life and in making that life tolerable, and in ending life in peaceful and compassionate circumstances. And we've seen changes in social attitudes to matters of choice, the greater autonomy of the individual, and the ability of people to make decisions about important things affecting their lives, free of bureaucratic and political interference. And we've seen, I think, the weakening of the influence of religion in the community generally, although as the numbers seem to be diminishing, the volume of their contributions seems to be increasing. And perhaps others may talk about that. But it's relevant because back a century or two ago, the Church had a very strong role in the making of criminal laws and other laws. It doesn't have that sort of role anymore, and I would argue nor should it. And there are legal developments that have already occurred in other jurisdictions which point the way for developments here. We have lawful voluntary assisted suicide in the Netherlands and Belgium and Switzerland, in Europe, in at least 3 states of the United States. And I discovered only recently that Georgia has a little-known facility whereby you can ask your doctor to assist you to commit suicide, and he or she can do it as long as he or she doesn't hold him or herself out as being willing to do it. In other words, you can do it clandestinely, quietly, without going public on it, and it's not an offence. But if you advertise that you're willing to assist people to do it, it is an offence. Now, how crazy is that? Now, that is, talk about the slippery slope and the floodgates arguments that people do. That is just a recipe, I would have thought, for disaster. No regulation at all. And I think those sorts of arguments that have been put forward in the past about opening the floodgates and embarking on the slippery slope to disaster have certainly not been evident in the jurisdictions where this can be done lawfully, and it is not beyond the wit of politicians, with the assistance of the community, to frame legislation that will have all the right sorts of safeguards, all the right sorts of regulation, enabling the right sort of control to be exercised over this sort of conduct. And that, I think, is what we are arguing for. Initially, as I say, voluntary assisted suicide, but then you might need to think about the situation of the person who has a terminal illness but has dementia and is not in a position to be able to reason and to give that informed consent to the conduct at that point in that person's life. Do we take it that extra step further and give the power to somebody else to make the decision? How do things like those agreements you can enter for your future care impact on all of this? And taking it one step further, should it be something that is available to people who simply choose, even though they're not suffering from an illness that's about to carry them away, to do this action to end their own lives? I think there may be things for the future, but we need to start somewhere, and I would suggest that the starting point is with the voluntary assisted suicide. I will just finish with one little story because it touched me very deeply when I was Director of Public Prosecutions. I had a few of these cases come before me, and I needed to make decisions about whether or not people would be prosecuted, if so, for what offences, and how the cases would be handled. Of course, the law was complied with in every case, but there was one case that particularly affected me, which is a case of an elderly couple living on the Central Coast, and it got a lot of publicity in the Central Coast media at the time, so I'm not telling you any tales out of school. And the wife had been suffering for many, many, many years with a progressive, physically debilitating disease. Her mind was sharp, her body was giving up progressively. And for some time she'd been bedridden. Her husband, they'd been married for many, many decades, was her sole carer, attending to every need that she had. She couldn't move without assistance. And he'd given up his job, given up his career, and tended to her on a full-time basis. The level of love between this couple was extraordinary to read about. And she begged to be put out of this situation. Life for her was just one day of misery after another, of pain, although painkillers were prescribed and she had good medical attention, but she wanted it to end. And she wanted him to have some free time too in what was left of his life, because he was getting on too. Eventually, on one evening, she took some sleeping pills that he'd been squirreling away, and when she was asleep, he held a pillow over her face and suffocated her, and she died. He called the doctor in, the doctor had been expecting her to die at any time from the disease that she had. Certified death on that basis. She was cremated, and the husband went off to visit their children who live overseas. When he came back, he walked into the Gosford police station and told them what he'd done, which I think is extraordinary. It says a lot about him and a lot about life generally, I think. The police had no option. He had murdered his wife. He was charged with murder. He was committed for trial through the magistrates' court for murder, and the matter came to me for decision about what would be done. There was an offer from the defence to plead guilty to aiding suicide, and by the application of the prosecution guidelines, not the strict letter of the law, I convinced myself that I could accept a plea of guilty to aiding suicide by a reasoning process which is recorded in writing and on the file somewhere. And he was dealt with in the magistrates' court and given a bond to be of good behaviour. In other words, no penalty added to his suffering already. Now, I would argue, consistently with, I hope, with what I've already said, that his case was not one for the criminal law. His case was one for some other kind of regime to have in hand that would enable appropriate steps to be taken with the full consent of the person who was surrendering her right to life. And I don't think the police should have been put in the position that they were. I don't think the prosecutors who dealt with the matter should have been put in the position they were, and I don't think the courts should have been put in the position that they were. So those are my observations on the subject. Thank you.